presentation this afternoon is about a dispute between United States and the European Community at the WTO in 2000. And I refer the blogger in the morning session. I could not see this the discussion on the list, but because I think probably the reason is not really regarding to the procedure issue or Southcentre issue, but the importance of this case, why it deserves our special attention, is it touches upon the issue who should bear the enforcement cost. And the strategy what United States applied is very interesting for the developing country to learn and to adapt. Put differently, if we could properly incorporate this strategy into the developing countries when we negotiate on the enforcement, it will be very helpful for us to for the further negotiations. Okay, I just want to have outline of today's presentation will be three parts. First, I'll start with the economic analysis. What is the principle of cost sharing? And then I will move to the issue who should bear enforcement costs, which using the case study, the U.S. Section 01105 of the U.S. Copyright Act, and then we could provide some sort of the strategical implications. Let's start with the principle of cost sharing. As we all understand, the reason why we should have an intellectual property the regime is trying to provide government intervention to correct market failure, because the subject matter on the IP protection is knowledge, and knowledge has the nature of the information. Because of non-exclusivity and non-rivalry, it will be likely have a market failure without the proper intervention of the some regime. And this is the optimum IP policy, and more specifically, it concur the static loss, for instance, like deadwood loss, and we have the monopoly rent will be transferred from the producer to the consumer to the producers. And in order to ensure the dynamic gain, this sort of the static loss will be necessary for the society to undertake. But what determines the effective level of the IP protection? In a very simple model, we should strike a balance between the static loss and dynamic gain. But in a more sophisticated game, then we should consider the enforcement cost into the entire picture. In this case, there are several different types of the enforcement to be taken into consideration. One of them is the administrative cost. Secondly, will be litigation cost and the cost of litigation error, etc. Here, we're trying to introduce this concept into one because, from the society perspective, it will be important to strike a balance, which is as following: the balance between the static loss plus enforcement cost with the dynamic gain of higher compliance. If the marginal benefit of additional dynamic gain of the higher enforcement could not really cross-cut with the enforcement cost as well as static loss at the marginal level, then society will suffering from the additional or higher protections. So the optimal IP enforcement is one that balances the marginal cost of achieving slightly greater compliance with the marginal benefit that derives from doing so. Then it comes up another issue: who should bear IP enforcement cost? Here we're trying to highlight the nature of the IPR. We basically have two types of rights: either it's public or will be the private right. Then IPR is clearly the private right, and according to the private law, it is the private party who should bear enforcement cost. And in public law, it is society, but again, well, to the taxpayer to pay the enforcement cost. But anyway, somebody would have to pay. But who should pay that? If you are the private party, privately right, you want to enforce it, okay, please pay the bill. This is the simple logic that is embedded into in the legal text. Now let's move to the second part to talk about what is this case study about. this case study, what the background issue of this the case is that in 1998, United States copyright made amendment on their 1976. What the challenging point between United States and EC is the Section 1105, particularly the subparagraph B. They challenged that point because United States make an exemption on quite a number of establishments, which is beyond lower than the 3,750 square meters. Those kind of establishments without really they're paying their royalties, and this their amendment was challenged by the European community, and the EU brought case to the WTO, and the panel made upheld that United States denied EC right holders benefits promised to the ECs and the right holders by TRIPS agreement. Then the issue come up with what is the level, what is the size of the compensation. This is the key point that both parties brought to the WTO arbitration. This is according to the DSU Article 25.2. So this is the very important issue before the WTO arbitrator. In more detail is, as we have seen, that U.S. Section 1105 is to expand substantially the exemption enjoyed by certain establishments from the obligation to pay royalty on some copyrighted music. And because of the TRIPS Article 9.1 has made Berne Convention Article 1 to Article 21 be part of the TRIPS agreement, then this obligation made the United States in violation to the TRIPS agreement. Okay, now let's see what is the party's argument. It's very interesting because what EC they put forward to the arbitrator is the one currently most of the developed countries put pressure on the developing countries. And what the United States adopted, what they proposed, is the one that is worthwhile for us to learn. So what European community does is, United States ought to pay compensation equal to the full amount of the royalty that would have been paid by United States eating and drinking establishment of less than 3,700 square feet, had all of them been duly licensed to transmit their copyright protected music. But United States say, no. They come to argue that the actual level of the benefit that have been nullified and or in part impaired, amounting to somewhere only between the 446,000 to 732,000. Let's compare the two numbers. It has substantially, dramatic difference between the two numbers. European community come up with a very big number, and then United States come up with only 1/50 of the entire compensation level. So let's see what European community really made argument. European communities, what the approach they adopted is a bottom-up approach. It composed of 3 steps. The first step is to first come up with an estimate of the number that qualified for the exemption under the United States Copyright Act. So it with this calculation, and then reduce the number that do not play the music. And then with this difference, they apply their applicable license fee, which is in their fee schedule collected by CMO, and then for the remaining establishment. This come up a very big number. But United States, what they made argument is, lost benefit ought not be based on the potential revenues, but rather on legitimate expectations. What is the difference between these keywords, potential revenue and the legitimate expectation, is there is involved a lot of high administrative costs and other transaction costs, which is composed of major part of transaction costs. And those transaction costs is the cost that should not be billed by our United States, either CMO or other organization, should be excluded from the revenue. Only the rest of the amount that could be transferred to the European communities. So key difference between these two is that either should be transferred the net revenue or should be gross revenue. And then United States, this approach, they call it the top-down approach, was agreed by the WTO arbitrator. let's see in more details how the arbitrator did it. And before that, we just want to highlight here again for in view of the transaction cost as well as the legitimate expectation. This is other key issues. So, W2 obligation, what we have seen in the TRIPS Article 45, there is issuer enforcement procedures must be available. But DSU places no restriction on the size of any compensation payment, particularly that don't limit compensation to the amount of the benefit that have been nullified or impaired. So now it's up to the arbitrator to make the award. And here is the award. The first point is that the transaction cost can legitimately affect the level of licensing. The second point, the actual size of the gross cost should not be neglected in calculating the benefit that the right holder can expect to realize from the TRIPS. And the legal environment and the specific transaction costs associated with collecting the fees jointly determine the magnitude of enforcement cost. Therefore, the level of the EC benefit that are being nullified is equal to the amount of the royalty payment that would have been distributed had offended amendment not taken place. So this is the key point. Those transactions must be excluded when we calculate those kind of the level of compensation. They come up with two steps of the calculation. Start with an estimate of actual license revenue paid to EC right holders by United States CMO in the 3-year period prior to 1998. When United States illegally extended the scope of exemption from the royalty payment. And then second step is deducted an estimate of royalty paid on behalf of users other than eating, drinking, and retail establishment. And then in the end, they come up with this number, which is much more close to United States instead of European Community argumentation. The reasoning of the arbitrator is as follows. First, right protected on Article 1101 Berne Convention should not be considered to be self-enforcing. Which in their second point is enforcement imposed cost as it evident from the fact that EC right holders choose to rely on the collective the management organization in the United States to assist them to collect their royalty fee. So you don't go straight to the government to request any kind of protection. You have to rely on somebody to protect your right. And then they know clearly this kind of activity involves the cost. And thirdly, enforcement activity ought to be planned on a cost-effective basis. This is what arbitrator provided. CMO license only enrolls establishments for which the expected revenue exceeds their transaction cost. If not exceed their transaction cost, it's a question mark to what extent or to what level such a kind of enforcement should be introduced. Now, let's come up to some kind of implication. What we should deal with this kind of problem, the strategy what we can learn from the United States is the one we could really share among our developing countries. The logic is simple. If you pay little, you are entitled to pay little in terms of IP enforcement. If you pay more, you are prepared to protect higher. If you are pay plenty of the money, we are sure we're going to provide perfect enforcement protections for your right. But be sure from the society perspective, the cost and the benefit must be equivalent. And we have to bear in mind the 2 points. One is strike a balance, and second is there is no free lunch. Although today is our free lunch, we have free lunch.